Hey, good afternoon, everybody. This is John Rhodes, of course, and I am fully decked out in my working from home gear today, just like just about every day. So this is, I guess, the new normal for me, for me at least. I know for many of you, the new normal is crazy busy schedules and working long hours, or maybe even having other sort of issues with employment, which a lot of people I know are experiencing, sadly enough, at this time. So I do wish everyone to be safe and healthy, and appreciate all the work of those who are certainly on the front lines of this. My wife is a CNA at the local hospital in Boulder, Colorado, and she's in the middle of getting ready to apply for nursing school. But she works up at the hospital 1 day a week, and so she's definitely on the front lines as well. And it's definitely a heavy, intense environment right now. So thank you for all you do. I know there have been some concerns expressed regarding assignments. I'll reiterate this each week. My number one goal in this class is for you to get value out of this class. It's not to uh, enforce any particular deadlines. I will work with you. I'm flexible. I want you to be able to get value and learn stuff out of this class. I know that the school, Southern New Hampshire, just came out with a revised late policy. So if you have questions about that, please let me know. But we're in this together, and we'll get through it, and uh, we will make sure that you get what you need out of this class. So just now realizing this is my quarantine beard. I guess it's a bit unkempt, but I apologize for that. This week we are in week 4, and I want to talk a little bit about privacy of medical records, and just the different laws governing medical records. As I've mentioned before, HIPAA is the general federal law that governs medical records, not just medical records, protected health information, which is much broader than medical records itself. So protected health information, HIPAA, is you can break it down into 3 different rules. So there's the privacy rule, there's the security rule, and there's the enforcement rule. I just want to talk about the privacy rule right now. The privacy rule gives you, as a patient, with some exceptions, the right to inspect, review, receive a copy of your medical records and billing records that are held by covered entities, so health plans, healthcare providers, clearinghouses that are covered by the privacy rule. So access is very important. HIPAA is very concerned with individual rights. In fact, the agency that governs HIPAA enforcement and audits is called the Office of Civil Rights of the Department of Health and Human Services. So individual access, personal access to records is very important. Only you or your personal representative have the right to access your records. A healthcare provider or health plan can send copies of your records to another provider or health plan only as needed for treatment, payment, healthcare operations. One of the various exceptions that may apply under HIPAA, and your personal, obviously your authorization as well. Now, I want to talk a little bit about the discussion question this week with respect to the privacy rule. But before that, you may or may not have seen that the various announcements that have come out just within the last week or so with respect to HIPAA and the COVID-19, which is very interesting. So back in February, the Department of Health and Human Services issued a bulletin as this was coming up, sort of just reminding healthcare providers the ways in which they can use and disclose protected health information when there's a public emergency. And so certainly for treatment, certainly for reporting to public health agencies for to prevent um, or or lessen an imminent public harm. These are all exceptions to the general rule under the privacy rule not to use or disclose protected health information without a patient's authorization. So that was in February. Now in March, they came out and said, okay, this situation pretty much constitutes a public health emergency, and so you can that's the exception you can rely on in order to disclose or use protected health information. And they said, okay, and we're also going to lift sanctions uh, temporarily for hospitals, at least, to do the following things with respect to protected health information. So things like, discussing protected health information with family members or caretakers and people like that. There are certain requirements that have to be in place in order to do that. Well, in March, HHS said that, okay, we're gonna allow you to do this. So, we're in an emergency situation. We're not going to sanction you or penalize you if you don't necessarily meet those requirements. Same with what were some of the others? So that was one of them. There were a handful of others that they just said, look, we're in a public emergency situation. We're not going to sanction you if you do these things. So there was that. And that, I believe, my recollection is that just applies to hospitals. Now just recently, within the last week or so, they came out and said, with Medicare's expansion of the telehealth availability with respect to the COVID-19 situation, they came out and said, okay, normally under there are specific HIPAA requirements, both from a privacy and security standpoint, that need to be in place for telehealth to occur. And they said, look, we understand these requirements are in place, particularly from a security standpoint, to make sure you have the right secure platform for telehealth to occur. If those aren't in place, we're in an emergency situation. We're not going to sanction you for doing telehealth that may not be in a manner that complies with these rules or requirements. You still need to do it in a non-public setting, so I can't just go out to a big, large gathering. Not that there are any anymore, but if I'm a healthcare provider and start doing telehealth in front of a bunch of people, it has to be in a non-public setting. But there are the other relevant requirements and rules. While they may apply, they're not going to sanction and enforce during this time on a temporary basis. So that at some point will change. There are some other things. Just real quick before we get to the discussion question, I want to talk about this dichotomy between federal and state law with respect to medical records. So HIPAA governs the security, privacy of protected health information, and it governs covered entities. So covered entities, there are three types of covered entities. There's healthcare providers, there's healthcare plans, insurance plans, and there's healthcare clearinghouses. So it governs what they can and cannot do, what requirements they have to comply with from a security and IT standpoint with respect to healthcare information, protected health information. Medical records themselves are also governed by state law. From a record retention standpoint, typically governed by state law. HIPAA does not have a record retention requirement for medical records. A lot of people say 6 years is the rule under HIPAA, and that's not correct. What HIPAA requires is that you maintain any HIPAA-related documents for 6 years. Things like HIPAA trainings, HIPAA patient authorizations, all the documents related to HIPAA, you're required to maintain for 6 years. That's what HIPAA requires. Medical record retention is governed by state law. And so that's governed by state law. There are also many states, if not all states, that have privacy requirements related to private information that would also govern health information, personal health information. There are also notice requirements. For example, if you're a doctor that closes or relocates a practice, and you therefore relocate the medical records. Not that you relocate medical records anymore because they're basically all electronic. However, you're relocating your practice or closing it down, you're required to give notice, typically to either the Department of Health of that state or the medical board. Because if a patient, let me give you an example. So in Nevada, for example, the medical record retention requirement is 5 years. And if you close down a practice or relocate a practice, and you still have some years left required to maintain those records, then you're required to give notice to the board. And if a patient wants access to their records, they need to know how to get a hold of you as the record custodian. So even if you close down a practice, you're required to either be the custodian or hire a third party to be the custodian of those records, so that individuals can access their records and know where and how to get those records. So that's very important. I want to talk briefly about the discussion question. It is by far my favorite discussion question in this class, because we've been talking a lot about this concept of legal analysis and following the IRAC method of legal analysis: the issue, rule, applying the facts, and a conclusion. And this is no different. This is how you're going to analyze this discussion question. So it's a sort of a privacy issue with respect to disclosure of health information. And there are two different scenarios. I haven't read it recently, but my recollection is that there's an inadvertent reading of a medical record, and then there's a subsequent disclosure to like a supervisor or someone else by a physical therapist, so or a nurse. It doesn't matter. Anyways, so the question in both scenarios is whether or not there's a breach. And so I think the instinct is to say, okay, well, they shouldn't have done that, therefore it's a breach. That is not how you would think about it from a legal standpoint, and that's the key. So the key, if you think about this from a legal standpoint, you know the issue, it's a privacy issue. What is the rule? Well, in order to understand what the rule is, you need to understand what a breach is. And there is a very specific definition of breach in the privacy rule that I'm going to post in this week's announcement that you should look at. And you can see that to even determine whether or not there's a breach, the very definition of breach itself requires an analysis of various factors. And there are a couple of exceptions in the definition of breach because lawyers like to ruin and complicate everything. So it is sort of an analysis that'll make you think. Understanding, reading that rule, reading that definition of breach is critical to responding to this discussion question. So I encourage you to look at that, cite the rule, and include it in your analysis. That'll be very important. So then apply the facts to that rule, and then come out with your conclusion. Is it a breach or not? Again, I don't care what the conclusion is. It doesn't matter. You can determine if it's a breach or not. If your analysis is reasonable, your conclusion is going to be reasonable. Like I say many times, that lawyers are typically not in the business of, sometimes they are, but sometimes they're not in the business of getting the right answer. They are only in the business of coming up with a reasonable answer to advocate for your client. So anyways, take a look at that. And if you have any questions, I am available, or if you need to discuss anything with respect to an assignment or anything at all, please let me know. Have a great one.